Okay, streaming is live, so we will once again welcome you to the Board of Adjustment hearing. And beginning with a few housekeeping issues. First of all is the roll call. And each member will state their name and whether or not they have any conflicts in this matter.
Andrew Rennick, no conflicts.
I'm Laurie Urquiaga. I have no conflicts.
Eric Chase, I have no conflicts.
Amanda Peterson, no conflicts.
Okay, thank you. I have a couple of statements that I should read on the issues of decorum and our authority. So although this is a public hearing, only the presenters and those invited by the committee may speak or ask questions unless otherwise invited by the chair. We ask you to wait to speak until you're called upon. When you're speaking, please be sure to speak into the microphone so that the record is clear. We ask you to state your name and your city of residence for the record. You don't need to give us your full address, just what city you live in. Please limit side conversations. They do interfere with the audio recording. And if you need to have a side conversation, please step outside. Do not attempt to interrupt or speak over people. Intimidating or threatening speech or behavior is not tolerated at any time. Please refrain from clapping, cheering, booing, or being otherwise disruptive during the hearing. And in terms of our authority, the board's authority to grant variances or act on an appeal is limited to that specified in city ordinances, such as exceptionally regular, narrow, shallow, or steep lots, other exceptional physical conditions, whereby strict application of the ordinance would result in practical difficulty or unnecessary hardship that would deprive the owner of reasonable use of the land or building involved. But in no other case do we have authority. The Board of Adjustment makes decisions on variance requests based on evidence and may only grant a variance if there's an unreasonable hardship related to the property. It may not consider financial, personal, or self-imposed reasons for a variance request. And in granting variances, the board shall prescribe any conditions it deems necessary or desirable. This is not a variance, but one of the things that we have to consider is whether or not that personal nor financial hardship can be considered justifications. We will begin with our first agenda item, our only agenda item in this case, which is that Walter Keane, on behalf of Daniel Larson, requests an appeal to the Board of Adjustment disputing a zone verification for a car wash in the SC1 Neighborhood Shopping Center zone located at 3645 North Canyon Road. And Jessica Donachie has the staff report.
Thank you, and well done on pronouncing my last name. That never happens. So the item in question is the car wash here located off Canyon Road. We have an aerial map on the slide and then just a rough timeline. The project was applied for in 1993. The conditional use permit was issued in 1993, and then the building permit was also applied for in 1993 and then completed in 1995. What brings us before you today is a zone verification that was issued in November of 2024, stating that there were no violations at the property. Our standard operating procedure when issuing a zone verification is to list if there are open code enforcement cases under the current violations. At the time this zone verification was issued, there were no open code enforcement cases for potential violations to be investigated at the property, which is why the staff report recommends denying the appeal, that there were existing violations at the property. Staff believes that the zone verification was issued correctly based on the information that we have. And that's all I have for you. Do you have any questions?
Andrew.
So the question before us, to be clear, is whether or not that zone verification was accurate.
Correct.
Not whether or not there are existing infractions that by law enforcement might take up. That's a different question.
Yes, they're appealing the zone verification because it states that there are no current violations at the property. So they're stating that that is incorrect. And our, as staff, operating procedure is to only list if there are open code enforcement cases in the current violation status.
So as part of that, no one went to the property to assess, current state of things. It was just that there's no open issues currently being investigated.
Site visits can happen in researching a zone verification, verifying parking, things like that. It's not often that we bring a printout of the code with us and do measurements, things like that, when doing a zone verification.
So I have a question. So if there had been let's see. And if a nearby neighbor had concerns about decibel levels or something, and there had been an open violation in the file, then you would have then investigated
Yeah, if
things.
code enforcement had received a phone call saying, I want to complain, I think that the noise level is too
Mhm.
loud, we would open up a code enforcement case, and if it was open at the time the zone verification was issued, it would be included on the zone verification.
Thank you.
Okay.
I just had a question. So the section on the zone verification letter where it says current violations, it just says none there, right?
Yeah.
So maybe the wording would be incorrect and it could say current enforcement cases, none, and less of a statement about if there are actual violations. Is that
Yeah.
what kind of the dispute is tonight, whether? Okay, I get it. Thank you.
Okay.
I would encourage a little more semantic clarity. I don't know if that's possible for the development office to consider, but I think it matters.
Yeah, we can definitely take that back and evaluate our forms so that they are more clear when they're issued. So
Okay.
thank you for that feedback.
Okay. If there are no other questions for staff, we will move on to the discussion. We'll first call the applicant. I don't know, is that going to be Walter Keane? If you would
Yes.
state your name and your city of residence, you'll have 15 minutes for your presentation. When your time is up, you'll hear a ding and the microphone will be muted. Following your presentations, if we have questions, we'll invite you to come forward. If we interrupt you for extensive discussion, we may be able to adjust the time, but usually 15 minutes is more than enough. So we'll go ahead and let you get started, Mr. Keane.
Oh, thank you so much. I appreciate all of you coming out here tonight. I know that there's other things to do besides listening to me. Tonight, Dan Larson and his family.
You do need to.
Oh, sorry, I
name and city
apologize.
of
I
residence.
apologize. I apologize. You did say that. My name is Walter Keane and my city of residence is Draper, Utah.
Okay,
Can I proceed?
that's
I
good.
can proceed now. Okay. So I'm here with Daniel Larson and his family. They have a home that's near the car wash and they're adversely affected. They hired me and we brought a nuisance action and filed it in district court. And as we're doing that, there's two types of nuisances. There's public nuisances and there's private nuisances. And when you look at a public nuisance, the way that works is to say that there's some type of a city ordinance that's being violated and that's a violation. So Mr. Chase, to go to your point, it's very important what you said, because we have a record here saying that there's no current violations. That zone verification letter could be used later in the court as proof or evidence that there is no zone violation. So I agree. I think that's something I'm hoping that the board will instruct the city respectfully that they have to clarify that because it'll be highly prejudicial to us. I just want to read something about the appeals to the board's power and duty. And this is a slightly different ordinance. It's 1404-030, not dealing with the variances. The applicant or any person or, and I'm reading from subsection 1, the applicant or any person or entity adversely affected by a decision administering or interpreting a provision within this title may appeal that decision or determination made by an official in the administrative or interpretation of the provision. And I kind of skipped there. And so what we have is the zoning verification letter, to our mind, says that this is a proper and legal use of the property. Now, from what I understand or discern from the staff report is that these zone verification letters are not a tool for enforcement. They're almost like an advisory thing. And I very respectfully want to push gently against that. And I want to cite a case. It's called VIAL versus Provo City. And it's an appellate court case. I don't know if, and that's a 2009 Utah App 122. And in that case, Miss Vial, I hope I'm pronouncing her name correctly, purchased a house in Provo City. And it had a mother-in-law basement. And this is a bone of contention for the neighbors because a lot of the kids rent and go to, or I should say, students go to Provo University, and there's some contention in the neighborhood. And guess what? This new owner who's been leasing out the mother-in-law basement gets a zoning verification letter from Provo City. And the letter states that it's a permissible use, but the mother-in-law apartment is not. And so in that, it deemed the rental of her basement apartment an illegal use. She then appealed to this body, and this is back in 2009. And this body heard evidence from the neighbors, and the neighbors said, hey, that wasn't, we talked to the owner previously, et cetera, and they relinquished that use. They stopped using that mother-in-law apartment. And so therefore you can't continue to use it. And this board made a decision, and it said, based on the evidence before us, we see that you are not allowed to use that. And what was the triggering event for that was the zoning determination letter. And that's the same thing here today. I don't know. I apologize. I don't know if I can forward things. So what this is evidence. And what I'm showing this board is the 1999 aerial photo of the car wash. And this is when it's built. It's kind of fuzzy, but you can see in the middle there's the Tim View car wash. And just below that, and it is fuzzy, is a house and a road, etc. And then I'm going to click it again. This is 1997. It's getting a little bit more clear. And then we go to 2004, and then we can kind of see it more clearly there. And then we go to 2024, and there we see it even more clearly. And now we see the presence of Dan's house just directly south of that. And then we see the zoning or the violations. Oops, sorry, here. And I'm not going to go through the list. The board has that list. I'm not going to be redundant. But you can see some pretty clear things. For example, the automated car wash has always been at the bottom closest to the residence, and that's in direct contravention of the ordinance. And there's other things like the 6-foot fence, etc. And unless this body has any questions, I'll just leave it there and just kind of point to my brief and where I enumerated the violations.
I do have a question on, you don't give us the date of these ordinances. Are you sure that those ordinances have been in this format since 1994?
I don't. And my response would be this. I went and I asked for grammar requests from the city before I filed this. And I'm like, was there a memo in the file saying that this car wash was built? And what I would say to you is that the city is responding to the staff report is not saying that this is grandfathered in or a legal non-conforming use that came into existence before the police power came and imposed the zoning ordinance. And so they haven't raised that argument. And so I don't think it's something that they can rely on or can be used. And so ultimately, what we're hoping for is just a recommendation back to the staff that they do a site visit and make a determination if there are any potential zoning violations. And with that, I'll leave it alone unless there's any other questions.
forgive me, question for you. So you talked about filing a suit in court, and we're privy to Mr. Larson's letter. Thank you.
Oh, I'm sorry.
Yeah, so I'm wondering, and it says that, let's see, let me read it. Tried to resolve the issue through the proper channel. So at some point, did the owner or did you file a code enforcement complaint with the city?
I contacted the city
Mhm.
and I asked, what's the process by which, this is the situation? And they told me to do a zoning verification letter.
Mhm.
If you look at the appellate court case that I cited, that zoning verification letter it said, yes, the family home is a legal use, but it's an impermissible, there's a zoning violation there. And for me, to me, that appellate court decision and saying, where the Provo has used it in this manner as an enforcement mechanism, to me, it seems to be a disparity, that my client says, hey, we've got the same thing as this, same kind of an issue as a illegal mother-in-law apartment. These are other zoning violations. And it seems so clear that if you go for a zoning verification letter, to me, it seems sort of straightforward that they would, look and make sure everything's okay. I mean, to take it to its wild extreme, I'm sure that there's prohibitions against Airbnbs or, verbos. And you can imagine like a adjoining landowner saying, my goodness, there's a new crew of people in this house. And Provo City says, oh, you know what? It's a legally permissible residential home. Current violations, none. Well, it requires a little bit more of an investigation. And that's what happened for the mother-in-law suite. And we're asking for that here.
Okay. So the remedy you're requesting is a site visit?
Yes, a site visit to determine if there's zoning violations. And in the alternative, if this board will not do that, I'm asking for a rewrite of the letter as Mr. Chase so clearly saw, that it just is a little bit, and also Ms. Peterson had mentioned, a little bit more articulate. So that's not used against us in the district court saying that there's no zoning violations here whatsoever. And therefore we cannot bring a public nuisance cause of action, if that makes sense.
Okay. Anything else from members of the board? Okay, thank you.
Thank you.
We will now move to the public comment portion of the hearing. When your time is up, you'll hear a ding and the microphone will be muted. Each person may make one comment. If we have questions, we'll invite you to respond to those at that time. This time is for comments only. And we will begin with neighborhood chairs. I believe we have one present. If you want to talk, no? Okay. You're not obliged to speak, but I do recognize that we do have a neighborhood chair here. Are there any other neighborhood chairs who would like to speak? All right, we will open it up to public comments. Each person will have 2 minutes to present their comment. And again, when your 2 minutes are up, you'll hear a ding and the next person can take the stand. Remember to state your name and your city of residence. So public comments now. Do we not have anyone who wants to make a public comment? I'll hold it for a few seconds. Just sometimes people have to make up their mind. Oh, we do have a neighborhood chair who would like to speak.
Sorry, my name's Sharon Mehmet. I am the neighborhood district vice chair. And my only questions really stem from the process. I haven't heard any complaints and not that they would come to me first, but when I did my own grammar request on the item, when I saw it come before you, I saw no list anywhere of any complaint to the city about the issue. And I understood that that was the process, I guess. If I have a problem with my neighbor that I can't resolve, that I say, hey, city, I think they're breaking the law. And the city comes out and looks at it. So whether, maybe to his comment, we've skipped a step in this process. And I'm, as a neighbor, failing to comprehend even what you get to do at this point. So I'd love to understand more. I haven't had a problem. I haven't heard of a problem in our neighborhood, in the Sedgemont neighborhood about this to this date. I'm sorry if there has been one and I hadn't heard about it.
Thank you.
I'm Dan Larson. Do you want my city too? I live in Provo. I was just gonna speak to that really quickly. Obviously, we've lived in the home for 13 years. And did our very best to first work with the owner of the car wash to resolve some of these issues. Some of them have been slightly resolved. I've worked with Terrell in the zoning office, had probably at least a dozen calls with him. I've worked with officers in the police office, in the police station about the noise. They've gone out and measured the noise and even admitted that it was over the noise ordinance, but basically said, I'm not going to stand out there all day and write tickets for every car that goes through the car wash. So I'm just not getting any help with enforcement based on their admissions that things aren't quite right. It feels as if the business is being given preference to us as residents. So thank you.
Thank you. Yes.
My name is Michael Field. I am the property owner of the car wash. The car wash has been there since the late 90s. Dan's home, if I'm not mistaken, went in 12, 13 years ago. I don't know what to say other than I'm simply trying to run a business. Thank you.
Okay, thank you. Anyone else from the community? Any questions for commenters? No? Okay, this is a novel question for the members of this board. It may have come through, there may have been something similar with a previous board, but we're trying to figure out what our authority is here, what our options are here. So I would invite Bill Pepperoni from the city to come up and talk to us a little bit about what the remedies are what the authority is that we have. I don't know if we could pull up the city ordinance that. Oh, yes. Okay, we'll close the public comment part, and then before we get to the actual deliberations, we'd like a little bit of input from the city. Mr. Keane gave us cited an ordinance section. I don't know if that's something that you could bring up and put on the board for us.
$1434,250, I think.
1405-030,
Okay.
subsection 1.
I'm just curious to see what that says. And then if you could let us know.
So in answer to your question, I'm not sure it is in the board's purview to assign remedies. I think it's your responsibility to rule whether or not the staff acted rationally and reasonably in the application of the ordinance or of the city's processes. In this particular case, the staff is not opposed to a continuance, so a site visit could occur to check some of the allegations being made. This is the first I've heard that the police department felt like there was a violation of noise, but didn't want to enforce that on some kind of regular basis. If that is in fact the case, then I think there should be some action taken. Intrusive lighting is something else that we can check. The first and fourth allegations about proximity to residential areas or lack of a barrier I think the ability to appeal those things are years and years and years beyond the window for appeal. So I'm not sure we could do much about those things. But the second and third items that have been raised are legitimate, and I think we should investigate those. So the staff is not opposed to continuing this item to give the staff the opportunity to do that and include that in our report back to you when you next convene.
Okay, thank you. And I am looking at this code section and I'm seeing stuff about variances and decisions, but it's the letter, the report that they did, the zone verification is an administrative action, right?
Yes.
Not a zoning action. So I'm
Well, it is a
still,
zoning action and it's administrative action.
okay.
Yes.
All right. Well,
Can I,
what do we want to do about this?
can I ask a question?
Yes.
So just play pretend with me here, right? Let's say that the city goes out and finds the decibel levels too loud. A continuance then would bring this back to this body, is that correct? Or would that then move to a different process?
Well, if we found a violation, I think the city should take steps to correct the violation.
Mhm.
So if we
Okay.
verified that, I think that we would work with the owner and
Okay.
turning down the volume so that something could be done. Depending on the remedies that we achieve and the attitude of the applicant, I don't know if we'd have to come back or not. It would
Hmm.
depend on the
Okay.
applicant. Also, I don't think the staff has proposed to a more finely worded zoning verification letter. But I'd like to do the on-site investigation.
Okay.
Bill?
Do we need to continue this in order to do that
Make them,
on-site investigation, or can we simply recommend that as part of our decision?
If you're comfortable with the staff taking time to do the investigation, I think you should just make a motion for continuance to your next meeting. Because I think we can handle all of this before we need to notice your next meeting.
Bill, as staff, we have to keep in mind that the statute says that we may enforce. So when you are stating that we should investigate and should try to remedy those violations, there should be some cautious there that some of them are not doable.
So that decision on what we enforce is the attorney's office, not my department. So just Ms. Burgess giving that as a kind of a word of warning.
Okay, just lots of clarification questions here. Please bear with us. As we're looking at this, one thought that occurs to me is that we could request that the reporting form be modified to say, instead of whether or not there is a zoning violation, whether there are any pending zoning complaints, in which case you would be saying there are no pending ones, but that doesn't necessarily answer whether or not something is fully compliant. It just says that there are no pending actions that you're aware of. But would it be appropriate for us to recommend anything like that in addition to a continuance, or a continuance puts everything on?
I would just recommend the continuance because I'm not sure I'm comfortable with what was just suggested. That has some other implications.
Okay,
So we can bring back to you more information on that next time you meet. I would like to just encourage or recommend the continuance.
all right.
So that's what you're
yes.
asking for.
So I'm seeing nods from the board. Do we have any discussion that we need to make on this? Or do we need to, we could get a motion if people are comfortable making that motion without any further discussion?
Does anyone have anything they want to talk about?
I would be fine with doing a continuance. I get their appeal that they want more specific language if they have other legal action that are zone verification is too proactive or assertive, that there's no violations when no one's done active research into that. So if we're
Right.
gonna continue that, and maybe if it comes back before us, we can address that in the next time.
And yeah, and the city can maybe talk to legal counsel about that language and what's appropriate. Would that be part of the motion for you to talk to, or you'll just simply do that?
We'll simply do that.
Okay. I think we can rely on that. Does anybody want to make the motion?
I'll make a motion that we continue item 1 as has been discussed until our next meeting.
Second that motion.
All right. Let's vote on that motion.
Andrew Rennick, aye.
Laurie Urquiaga, aye.
Eric Chase, aye.
Amanda Peterson, aye.
All right.
Thank you.
That concludes the discussion of item 1. And let me go back to see what's doing. All right. Do we have any other business that we need to take care of at this time? I don't see anything on the agenda. Hearing nothing, we will adjourn until our next meeting, so that the city has time to investigate this property and consider other requests from the applicants. All right. Do we have a motion to adjourn?
I move to adjourn.
All in favor?
Aye.
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 Thank you.